you. How are you, Makanata? Long time.
Hi, Paul. How are you?
Am I ashamed or you are ashamed? You know? I mean,
I think we both are.
it can't be Elizabeth to bring us here. Come on, eh? We need to do
I
better.
understand.
Yeah, for sure.
Yeah.
I will touch base after this, you know.
Yeah, we need to do something.
We need to do so. Thanks.
Hello, Arnold. Hello. Can you hear me, Arnold?
Hi, Liz. I can hear you very well.
Okay.
I'm also very happy to see Justice Charles Uhungwe, Dr. Makanata, Maxine, and the evidence that Paul may be here through the name.
Okay.
Good afternoon, everybody.
Hello, Maxine.
Hi, Elizabeth.
Yeah, how are you?
Good, thank you.
Yeah.
Afternoon, Makanasa. Afternoon, Arnold.
Hi, Maxine. How's it?
Maxine.
Good, how are you?
Very well.
Good, thank you.
I'm sure the rest of our team will be joining shortly as well.
Yeah. Hello, mi Amanda. Hello.
Good afternoon. How are you?
Good afternoon. How are you?
Good. Fine, thank you.
I think I was just waiting for it to be 2 o'clock before we start. Just a minute. Okay. Good afternoon, everyone. I'll call the House to order. My name is Elizabeth Orakuba. I'll call on Mr. Arnold Songa, who is the Senior Legal Advisor, Election and Rule of Law. He's going to be making the opening remark on behalf of the Secretary General of AJJF, Mr. Martin Masiga. Mr. Arnold, you have 5 minutes for this. Over to you, sir.
Thank you, Liz, and thanks very much for the kind introduction. Yeah, and as Elizabeth has said, I'm currently associated with the Africa Judges and Jurists Forum as an advisor on elections and the rule of law program, and I've been asked by the Secretary General, who is Martin Masiga from Uganda, to say a few remarks in opening. So the Africa Judges and Jurists Forum, it's an eminent group of judges and jurists from across the Africa region, which existence in order to promote the concept of the rule of law and development. Sorry, I got into some interruption. So to focus on the rule of law and development in Africa, and in terms of its structure, it is led by the Secretary General, who reports to a board that is currently chaired by Justice Chinengo, who sits on the Court of Appeal in Lesotho, but is also currently sitting in Namibia. Then we do have the Judicial Elders Council, which I think is one of the most important organs of the AJJF, that is composed of former Chief Justices. Currently, Justice Willie Mutunga is the president of AJJF and Jack, and he's joined in that position by Chief Justice Othman, retired from Tanzania, Chief Justice Maraga, retired from Kenya, Chief Justice Nyirenda, retired from Malawi, and Chief Justice Sakala, retired also from Zambia. There is another member who is really phasing out, Chief Justice Lehotla from Lesotho. But we use the JEC, which is Judicial Elders Council, to do what I can call the high-level advocacy of law to strengthen justice delivery, but at the same time to offer mentorship to judicial leaders in Africa. And it is a very unique organ in that our Chief Justices who retired and were still quite mentally lucid and very useful for advancing the rule of law in Africa, were finding themselves without a structure that they could use to defend independence of the judiciary, but also to advance the rule of law, good governance in Africa. So we're quite privileged as an organization to have that structure. And maybe moving to the theme of our conversation, which is essentially judicial independence and civic space. It is that with a weak judiciary or a co-opted judiciary and an independent and unaccountable judiciary, there's absolutely no way that a society can have a structure that can effectively defend civic space. And, civic space is so important because if you look at civic space rights, the fundamental rights of association, assembly, movement, these are rights that are absolutely foundational to democracy, to effective civic engagement and civic participation of people in matters that affect them. And so without an open and free civic space, it is not possible for Africa to be able to, consolidate on its path of democratization. And then on that basis, we are very interested as an organization and extremely conscious that we need to create these unique spaces where we get judges who are highly interested in protecting independence of the judiciary and rule of law and separation of powers and checks and balances, to work together with civil society leaders in a collaborative way to reflect together on how best to protect civic space. I don't think there are many organizations that have got this ability to do that, and that's what makes me very, very proud to be a member of Africa Judges and Jurists Forum, and then that space then allows us to get judges and civil society leaders to Cularis for organizing this, and the collaborating partners, Civicus, there's Paul Mulindwa, and Southern Defenders. I see Amanda on the screen. Thank you very much, and back to you.
Elizabeth, I think you're muted.
Yeah, sorry for that. I would like to remind everyone that the webinar is organized by African Judges and Jurists Forum, SADCLA, Southern Defenders and CIVICUS. Then we have a line of distinguished speakers who will take turns to address specific issues on judicial independence and civic space in Southern Africa. I would like to mention on board that we have George Charles Hungwe, Dr. Makanasa Makunese, and Dr. Paul Milindwa. They'll all be making different thematic, they'll be giving different presentation on different areas as it relates to judicial independence and civic space in Africa. Dear participants, if you have thoughts, comments, or questions, you can post them on the chat box at the plenary section. Your questions or comments or thoughts will be answered. Then I would like to quickly introduce the first speaker for today. He's a Supreme Court judge. Is the currently the chairman of the Judicial Action Group, a pair-led voluntary association of judges on the African continent. I have the honor to invite Justice Charles to make a presentation on judges' perspective on the state of judicial independence and civic space in Southern. Over to you, sir.
Thank you. Yes, ladies and gentlemen, I'm very greatly honored to be among such eminent luminaries who make up the panel for this webinar. In my capacity as the chairman of the Judicial Action Group, which I suspect most of you may not have heard about up to now, I'd like to give just a brief outline in 2 sentences what Judicial Action Group is about before I delve into the topic at hand. As the introducer has intimated, JAG is a peer-led group of judges on the African continent committed to put the African jurisprudence and sharing their lived experiences of sitting judges, superior court of countries in Africa. And our vision is to send every member state of the African Union a part of JAG. We share a vision that hopes to carry original thinking from the continent that is directed at using the law to address shared global challenges such as climate change and issues to do with human development. Like AJJF, JAG is committed to the use of the law to promote the rule of law. As the first step, JAG has recently launched its first publication titled Ubuntu in the Age of Human Rights, and it will be available online shortly. Now back to the topic. The topic, judicial independence and civic space, resonates with us in JAG, reminding us, as it does, of the importance of those people with consciously and sometimes unconsciously in our professional lives. I will share with you a perspective from the bench, and I hope that sharing these perspectives enriches mine and your experiences and energizes us to face the difficult task of navigating the ever-changing values of our society. There has been a substantial amount of literature around the concept of judicial independence and the factors surrounding it. A perusal of this extensive literature reveals why so many free and democratic systems and societies find forms of judicial independence advantageous and therefore incorporate them into their systems. This raises the question of whether judicial independence strengthens democracy. There is often debate about for and against the idea that is identified in the literature. However, generally there is acceptance of the ability of the courts to provide the necessary legal checks and balances against other branches of government. And the judiciary plays a a vital role in the development of democracy. However, there's been debate about whether this is always the case, that judicial independence does play any part in development. This short paper is meant to provoke debate on the subject. An African Commission case is used to explain the terrain covered by the topic under discussion, and I will seek to share some perspective of the matter of judicial independence and civic space as follows. At the very basic level, as noted by Martin Shapiro, judicial independence is related to the notion of conflict resolution by, in quote, a neutral third, which in other words, someone who can be trusted to settle disputes by considering only their relationship with the relevant laws. Therefore, judicial independence in its theoretical underpinnings constitutes other fundamental principles such as judicial impartiality and the rule of law. In this way, one can say it is a building block to the trust that society reposes beneath governmental architecture that adheres to the doctrine of separation of powers. Now, impartiality in this sense refers to a state of mind or attitude of the tribunal concerning the parties before it in its adjudicative function. On the other hand, independence in this context suggests not only a state of mind in the exercise of judicial functions, but also a status or a relationship to others, specifically to the executive branch of government, which rests on objective conditions or guarantees. Therefore, you'll find that in most cases, in virtually all cases, there is a constitutional provision in each constitution which guarantees the independence of the judiciary. And therefore, the importance of impartiality cannot be overemphasized with regards to the independence of the judiciary. Conduct by other political arms of government that gives an impression of that, or some other impression other than impartiality in the public's mind, that the judiciary may not be a legitimate component of a triad structure, but rather a politically based actor. Where, for instance, if for any reason the executive generally, it is the one that is the culprit in most of these cases, creates an impression that it is in control of the judiciary, that creates in the mind of the ordinary person a belief or a perception that such a judiciary could only bow to the whims of the executive. And once that is created, the confidence in the judiciary and the independence of that judiciary is severely impacted. And Green suggests that democracy is founded on the principle of mutual respect, and he gives the 5 sub-principles that derive from mutual respect as social equality, the deference to the majority where consensus cannot be reached, protection of minority rights, respect for individual freedom and integrity. One can see that these principles in turn create 2 basic duties for public officials and judges especially, which is impartiality and the duty to act in the public interest. And all these 5 sub-principles rotate around the question of trust. Therefore, it can argue that judicial intervention in any political system will have profound influence, since it creates or is the link between the state and the citizen, as well as the relationship between various social actors. Now, there are so many threats to judicial independence which impact on the existence or reduction in the civic space. Russell Elliott writes after a review of the political terrain in Southern Africa, in Africa in general. She writes that a defining characteristic of hybrid or semi-authoritarian regimes is an uneven and inadequate adherence to the rule of law. That is further evident by the region's poor ranking in the World Justice Project Rule of Law Index. An effective legal system and judiciary are essential to secure both good governance and democracy. Now, a feature that has contributed to the deterioration of rule of law values in our region, in my view, relates to what is termed judicialization of politics. This has placed the courts at the center of dispute resolution that includes electoral, high-profile corruption cases which involve political elites. Judicial review itself has assumed high-profile relevance when it comes to the review of controversial legislation. What appears to drive this factor or phenomenon is power retention by political groups or individuals who appear to seek the use of courts to achieve their political objectives. One can argue that judicialization of politics has been credited by, with the prevention of collapse of the rule of law and order, and that it, in a sense, brings formality and stability to society, and otherwise prevents potentially violent political conflicts, thereby empowering the judiciary's profile in the community. Now, that may be so in the sense that when people resort to the use of courts, it must be applauded, because rather than having to settle their disputes violently, a resort to legal process is what the Constitution requires. But it is not always the case that the judicialization of politics is evidence of an empowered judiciary or an independent judiciary. This is because in politically volatile settings, high levels of judicialization of politics frequently relates or corresponds with increased public scrutiny and governmental interference with the courts. I think it's two sides of the same coin, because judicialization of politics cannot escape blame for the grave weakening of judicial legitimacy and the rule of law in instances where this has happened. We see this every other day in almost every country where electoral disputes flow into courts, and thereby giving the courts the power to determine who runs and who does not run in any electoral contest. But the problem with that is that where there are strong groups, or where there is a predominant or de facto one-party state which controls levers of state power, this judicialization of politics tends to have a domino effect, in the sense that all institutions of government, including the judiciary, will tend to emulate the practices of the political elite, who have a tendency to want to influence processes. And therefore, judicialization of politics cannot escape the blame for the weakening of both governmental systems and judicial legitimacy. But this has been, in most instances, blamed on the lack of constitutionalism with regards to those states where there is an almost breakdown of the rule of law in a specific area. And the lack of constitutionalism has been identified as the biggest source of overall political and governance problems, which manifest in those jurisdictions where judicialization of politics is rife. But judicialization of politics in a state, as I said, tend to have a domino effect on judicial administration, and this is exactly where I am of the view that it spawns or multiplies the problems regarding all the values of that are associated with judicial independence. I have in mind the case of Justice Thomas Masuku versus the Kingdom of Swaziland, which is an African Commission on Human and People's Rights communication number 444 of 2013. Just to illustrate the point that I'm trying to make regarding the political problems overflowing into the judicial arena. In 2011, June 2011, the Chief Justice of Swaziland, in his capacity as the chairman of the Judicial Service Commission, laid charges against Justice Masuku and called upon him to show cause why he should not be removed as the judge of the High Court. He faced 12 charges, and among those 12 charges were the following. One, insulting His Majesty the King by using the word forked tongue with reference to the king, and this was in a judgment. And two, touting himself to be promoted Chief Justice, especially amongst chiefs. As the matter panned out, the disciplinary proceedings set against Judge Masuku were interdicted by a court process after the judge who was assigned to preside over those proceedings recused himself, holding that because of the closeness and the small size of the judiciary, he was too closely associated with the judge that a foreign judge ought to be robbed into preside over the process. But as it turned out, the matter proceeded to finality with the result that Justice Masuku was relieved of his duties as a judge of the High Court through a royal decree. And this is what led to him approaching the African Commission. In its assessment of the complaint, the African Commission made very serious findings against the political judicial environment prevailing at the time in Swaziland. This case also demonstrates the dangers and the dangers attendant to a head of the judiciary wielding the stick on behalf of the executive. One of the charges, as I said, related to the term of the term used by the judge in writing a judgment, in which there was reference to the king having spoken with a forked tongue. But what is of concern to me is the fact that the Constitution of the Kingdom of Swaziland of 2005 provides, like most post-1990 Southern African constitutions, all the jure protections necessary to uphold the independence of the judiciary. It has appropriate fair trial rights provisions. It provides for the security of tenure for judges. it requires judges, like every other public official, to be accountable for One of the charges laid against the good judge was that he had voiced his disapproval of the ban of by the Chief Justice on speaking to the media when he was outside Swaziland. Of course, the Constitution of Swaziland provides all the rights and freedoms, including the freedom of speech, freedom of association, and all the attendant rights that are guaranteed constitutionally in all democratic societies. The Constitution itself claims to be a democratic constitution of the Kingdom of Swaziland, and therefore it espouses all the democratic values that we all know and practice. Yet, in the most sacred halls of justice, this case spawned and spiraled out of control, with the result that without recourse to due process, the judge not merely left his office unconstitutionally, but was deprived of his right to exercise his profession. His name was dragged through the mud. Those people who came in support of him, in support of his cause, like journalists, were equally ill-treated by the authorities for covering the matter. The result was that Justice Masuku has had to practice his profession outside of Swaziland. Now, civic space allows for free expression and participation of citizens in the democratic process, while democracy ensures inclusive governance. Judicial independence ensures that the judiciary can act impartially, upholding the rule of law and protecting citizens' rights. When these elements work together, citizens can freely engage in civil society. Elections are fair, and the judiciary can provide checks and balances, ultimately strengthening democracy by promoting transparency, accountability, and the protection of individual rights. On reflection, despite the provisions in the Constitution of protection of rights, it is the practice on the lived reality of the citizens that matter, that gives life to the democracy that we all aspire to. It is the practice of those who wield power that builds trust of the citizen in the democratic institutions that we set ourselves for in our governance. And we really need to reflect as to how we can strengthen these systems so that everyone can enjoy those protections and the rights that come with the rule of law. I thank you.
Thank you very much, Judge Hungwe, for that beautiful and insightful presentation. You can point from what you have said that the freedom of speech and association guaranteed under Constitution is not always adhered to. The judiciary can act impartially and uphold the rule of law. Then the judiciary can promote checks and balances so that the judiciary can promote checks and balances. Thank you very much, Judge Hungwe. I will now hand over to my colleague, Ms. Maxine from St. Clair, who will be taking the next session.
Thank you for that, Elizabeth, and thank you so much for your presentation, Judge. The speaker that I will be introducing next is Dr. Makanata Makonese. She is the American Bar Association Rule of Law Initiative Country Representative in Angola. which leads a country portfolio that includes a 3-year rule of law program focusing on judicial strengthening with a coalition of Angolan legal professional organizations, civil society, academics, and select government stakeholders. The program creates a robust dialogue around judicial processes, decision-making, and constitutionalism in Angola, and supports judges directly with capacity-building activities, improving judicial independence and effectiveness. With that being said, I would like to give the podium over to Dr. Makanata.
Thank you, Maxine, and good afternoon, good morning, good evening to everyone, depending on where you're joining us from. As indicated by Maxine, I'm currently working with the American Bar Association Rule of Law Initiative as the country representative in Angola, where we are running a rule of law program focusing on judicial strengthening. The program focuses or has got objectives of ensuring that Angola's legal framework for judicial independence is strengthened and that citizens demonstrate improved awareness of their legal rights and responsibilities, and that judges and courts have increased ability to manage and adjudicate cases fairly and effectively. The program is being implemented with different partners, including the Angolan Bar Association, who in turn are a member of the SADC Lawyers Association. So because my insights are going to be drawn mainly from this program, which focuses on judicial strengthening in the country, I thought I would give a brief background to that program. So in implementing the program, we are working with a coalition of Angolan legal professional organizations, including the Bar Association, like I indicated. We are also working with civil society, academics, and select government stakeholders to create a robust dialogue around judicial processes, decision-making, and constitutionalism in Angola, as well as to support judges directly, judges and magistrates and other judicial officers, with capacity building activities with the expectation of improving judicial independence and effectiveness in the way. So one of the things that we have learned through the implementation of this program and using this approach is that one of the biggest threats against judicial independence is the absence of multi-stakeholder platforms and approaches to fight for access to justice and independence of the judiciary in any country. This is because many of the citizens and stakeholder organizations believe that they do not have a role to play in a debate around judicial independence, as they think that it is the responsibility of lawyers to be engaged in such debates, and also maybe the executive should be the one to address that issue or those issues when they arise. And I think from this realization also see that it takes away stakeholders from the realization and understanding that judicial independence is not about the judges, but about society and the protection of our democracies, civic space, and human rights, which is very critical. And therefore, I would think one of the ways in which we can address this is to ensure that we have a multi-stakeholder approach in raising awareness about the importance of judicial independence and rallying every citizen to this cause. So I think this is an important issue that we need to focus on as civil society, but also as lawyers and other actors in this space to ensure that we do not monopolize the discussion on judicial independence, but we realize that this is a critical issue aspect for our countries, for our societies, and at the end of the day, we should ensure that we include everyone, we include as many actors and individuals as possible in order for us to be able to realize this issue. The second issue I would like to raise, and also I think something again that we have learned from implementing our project, is that the lack of functional and financial independence of the judiciary at institutional and personal levels also has implications for independence of the judiciary in our countries. While in many of our jurisdictions, the judiciaries have got legally and constitutionally allocated independent budgets, what we have seen or what we are realizing in implementing this project is that in reality, the strings are pulled from behind the scenes in terms of the actual release of the budgetary allocations, And this compromises the institutional independence of our judiciaries. They often have to beg in order for their budgets to be released. And often, instead of the releases being done in terms of cash allocations, they are given allocations in kind. They get things like televisions here, a generator there, a car here, and sometimes even houses and so on. Whilst we believe that such resources are necessary conditions of service for our judiciaries, the challenge is the manner of allocation and sometimes the timing of those allocations that compromises our judiciaries and their independence, as this presents the executive as a savior of the judiciary instead of a government arm that is simply fulfilling its constitutional mandate. Where such provisions have to be made, I believe they must be made as part of contractual undertakings and standard conditions of service, whose allocation and provision is not discretionary. At an individual level, we have also noticed that deliberately remunerating judges, magistrates, and other judicial officers poorly raises the same issues as I've indicated above. It also impairs the dignity of our judges and magistrates and other judicial officers in the eyes of the public and other actors, including lawyers, for example, who often argue that they are better remunerated or they earn more than the judges that they appear before, the magistrates that they appear before, leading to them, having a very condescending attitude or approach towards our judiciaries. I was in the province of Cabinda in Angola just yesterday, engaging with magistrates, lawyers, and other civil society actors on this same subject. And the lawyers in that province of Luanda, of Angola, actually reported that they often to magistrates when they see them waiting for public transport in the hot sun or in the rain. And when they do so, all sorts of conspiracy theories often arise, especially if the lawyers are arguing a case before the magistrates concerned. There are allegations that as they give the rights to the magistrates, there are discussions, relating to the cases, and corruption or bribery can actually take place as a result. While this is generally not the case, the lawyers also indicated that there are instances where such discussions can actually take place under those conditions, and the magistrates become compromised as a result. I think the key issue is that functional and financial independence of our judiciaries is important, both at an institutional level and an individual level. Avoid the judiciaries getting compromised at different levels and by different people, including the executive, the private sector, individuals, and even lawyers, like I pointed out above. We also discussed in the same meeting the importance of the appointment and removal processes of our judicial officers, both in the higher courts and in the lower courts. Often we focus on appointment of judges to higher courts and the need for the process to be transparent and independent as a way of ensuring the independence of the judiciary. We equally scrutinize removal processes at that level, at the higher court level, to ensure that they are insulated from victimization of targeted judges. However, again, during that discussion, the Bar Association in that province, the Judges Association, the Prosecutors Union were all agreed that there is need to equally pay attention to the appointment and removal processes at the lower courts levels as well, because justice officials at these levels are equally a target of compromise and manipulation by the executive and other actors. It is equally important, an equally important level in the discussion about civic space in particular, because it is usually at this level that human rights defenders and other civic actors are brought for initial court appearance and even for trial for exercising their rights to freedom of expression, association, assembly, and so on. So if this level of the judiciary is compromised, the chances of the judiciary being used to shrink the civic space becomes very high. So whilst we have made, I do not have an answer at this point as to how we can also deal with the issue of appointment of judges or judicial officers or magistrates at a lower level. But I think whilst we have made significant progress in terms of strengthening judicial appointments and removal processes in the higher courts, a lot still needs to be done to ensure that similar protections for the lower courts and the judicial officers at that level are actually put in place. And as we know, in many of our countries, especially in Southern Africa, most of the caseload that is by our judiciary is actually handled at the lower court levels. Hence, the need for us to be really concerned about what happens at that level of our judiciaries as well. And the fourth issue that I would like to discuss is in relation to the judiciaries being a threat to their own independence. While sometimes we presume that the independence of the judiciary is threatened externally, we have also realized that the issue can also be an internal problem within the judiciaries themselves. For example, we have seen lawyers being threatened in some of our jurisdictions for questioning the independence of the judiciary. And where their comments are in relation to cases that are already before the courts, they are often targeted with contempt of court accusations by the same judiciaries and asked to explain themselves to the judges concerned or even to the Judicial Service Commission. While we all know that contempt of court proceedings are an integral aspect in the protection of the dignity of our courts, it becomes a problem when the procedure is used to silence critics and those who question the level of impartiality of our courts in the implementation of the mandate. And also when the judiciary simply refuse to acknowledge that they are targeted or that their independence is compromised, it becomes more difficult for lawyers and other civil society actors to try and defend their independence and support efforts for the creation of conducive legislative, constitutional, and institutional frameworks for effective judicial functioning. So I think it's also an area of concern or focus where we should really put our energies as lawyers, as well as civil society actors, to ensure that we identify threats when they arise from within the judiciary to the independence of the judiciary. Because at the end of the day, as long as the threats are coming from inside, it becomes even more problematic for us to engage and try to address some of those issues. I think with that, I've come to the end of my brief presentation. Thank you very much, Maxine.
Thank you, Makanata, for that insightful presentation. Thank you for highlighting all the threats that the judiciary faces, especially within the system, and the issues that they may face outside the system. And I really believe it is very important for us to have mechanisms as lawyers that safeguard the judiciary from internal and those external threats that they may face. Our next speaker that I'm going to introduce is Dr. Paul Mulindwa. He is a governance and development practitioner with a PhD in politics and international relations from the University of Johannesburg. He holds an MPhil in policy development and practice from the University of Cape Town, an MA in human rights from Makerere University, and a BA philosophy from Pontifical Urbania University in Italy. Dr. Paul has extensive experience of about 20 years in governance, development, international relations, and peace building in Africa, and he has worked with various international and regional organizations. He is currently the advocacy and campaigns lead for Africa with CIVICUS, which is a global alliance for citizens' participation. With that being said, please may I hand over to Dr. Paul Mulindwa.
Thank you very much, moderator. Standing on all the protocols as mentioned, I thank you for this time. I thank the Judges Forum and other partners that coming together and reorganize this very important discussion in our space. As mentioned by two colleagues, Judge Charles and Makanata, there is a lot of threats to judicial independence. But maybe if I missed it, apologies. But what is not clear, which would be my starting point, is threats from who? We can all see that all based on what they have mentioned, there are threats, different types of threats, but from who? from our perspective as civil society organizations and our work at Civicus, we realize that there are threats from different angles: state actors, non-state actors, including the business, the companies, individuals, all pose threats depending on different circumstances. As mentioned earlier, it could be, the judgment is coming out, then you hear individuals, threatening the judges, or a company X is in court for some issues, and then, threatening, and we've had some experiences and sharings of state captures in some countries, and you will find out that the judiciary is captured. So all those are threats. So in order to have an independent and a vibrant civic space, which is the fundamental pillar of a democratic society, the judiciary needs to be a standalone and an independent, open-minded institution in order to protect civic space and fundamental freedoms. But of course, what we see and what we've heard from previous speakers, this region, Southern Africa, continues to face some challenges. So to address some of these challenges and to put in place stopgaps that can shock absorb, if I can use the word, those challenges, there are some approaches, some steps that we may need to put in place in order to have a vibrant judicial institution, in order to have open-minded, open space for our judicial actors. And in here, we have judge in the house, but we can also talk about the court officers. It could be advocates, could be attorneys, could be, all those that are included in that category of judiciary, such that because if an attorney, or an advocate is also captured, his space is closed, then I don't think he will be able to advance debates, discussions, arguments that lead to fair justice and observance of human rights and constitutionalism in all our spaces. So one point I would need to look at is strengthening legal protections. In here, we find out that judicial independence and civic space, sometimes there is a lack of, within that space, there is lack of robust legal protections in some of our countries, to the extent that then it is porous, it is not very strong, and as such, we require amendments, we require resolutions that governments, states and non-state actors, can take in order to have a robust safeguard that bring covers against political interference for the state actors, that would also guard against disrespect for human rights by non-state actors, so that those can be guidelines for how actors, individuals engage with judiciary. Because without, as we have seen in some countries, without a robust legal framework, we will find intimidation, we find harassment, arbitrary removal of judges because Judge X is maybe not upholding the decisions or the aspirations of, let's say, sitting government. Therefore, motivations or instigations to remove him are ripe. So, but if we have a strong, robust legal framework that can protect such abuse of power, then we'll have a vibrant judicial, I mean, a vibrant and independent judicial institution. Capacity building is another aspect that we can use in order to strengthen the independence of our judiciary. And in this, I know they are learned colleagues, but sometimes I always say that we can say they are learning colleagues. Things change, trends keep changing. New international, regional human rights and fundamental freedoms, how do you call them, instruments keep coming. And as such, judges and judicial all judicial officers may need to be appraised on some of these new instruments and new trends, because one would agree with me that in the recent times, the trends or the mode of repression and closing of civic space is taking different directions. It is not only to tell you that, you know, you can't say this, will remove you from the power, but there are very different dynamics in different countries, not to mention names here, that judges go through, that judiciary go through, which also hinder their independence. So in order to bring them to speed, to understand some of these dynamics, so there is a need for skilling, refresher courses, so that they get to know what is out there. Then public awareness, as Judge Charles mentioned, sometimes judges' confidence may go I mean, may be soiled by statements, state actors or non-state actors. And as long as the society takes away that confidence, then it becomes a problem. But now to engage with the society, to engage with the community, this is where we need public awareness campaigns, public awareness programs. And in here, this is where I always encourage, of course, I'm conflicted, the judiciary to work with civil society organizations, because civil society organizations, truth be told, reach deeper in terms of grassroots, rather than in some countries, of course, the judicial institutions. And you will realize that these campaigns also can help to foster public support. They can counter that narrative, maybe by a state or non-state actor, in terms of reducing the image or damaging the image of judiciary. In some instances, I mean, when you read the literature, you will find out that sometimes the judges, you know, course of work, judgments, court judgments are also informed by the societies, whatever society is going through. And how will the judge know what is the society going through, what is happening in the communities, if the engagements with communities is less? So encouraging community engagements and awareness would be a good strategy towards this. Then international engagements, cross-border, cross-regional sharing and experience and learning, SADC, East Africa, you know, ECOWAS, so that they learn what other regions are doing. And then the strengthening of oversight bodies. Good enough in SADC, we have national human rights institutions, some countries different ombudsmen that can help to protect some of these thematic issues are in civic space. So strengthening them, ensuring that these bodies work hand in hand with the departments or ministries, work hand in hand with all the the three layers or levels of government, the judicial, executive, and the legislature, to ensure that the separation of power remains and the judicial work or the work of judges out there, the court officials is protected. This can help us to strengthen and put the vibrant and independence of the judiciary in place. Dialogue and advocacy, as well as empowerment of civil society organizations to ensure that they all work in collaboration, they all work together to bring what is in the society, what are the challenges on the ground, such that everything is shared, everything work with one another. What we tend to see as my concluding point is you find civil society works alone, judges or the judiciary is on the other side, and they tend to look at each other as opponents, so to say. Civil society may be sometimes looking at judges that is government, and then the working relationship is not the cordial one, is not a good one. So in this sense, working together, bringing all the stakeholders in dialogues and engage with government officials, with civil society, with stakeholders, communities, other opinion leaders and institutions in countries, for instance, where like in Eswatini, where the structure is a little bit different compared to others, traditional structures in Lesotho, so that everyone, all the structures are involved, and that can help to protect the name, to protect the face and the vibrant work of the judiciary. Thank you very much, the moderator.
Thank you very much, Dr. Paul Mlindwa. Thank you so much for your very informed presentation. It was very informative and very educational. What particularly stood out to me was your references to the cross-border services, exchange of services. I think it's very essential in this world we're working in right now, to open up the borders and allow for cross-border services within SADC and within our other regions surrounding us. So thank you for that. I will now hand over to Ms. Mande for a plenary session. And in this session, you can ask all your questions and put them in the question box here in the chat by on the Zoom application, or you can put your hand up once she has taken over and give her your questions if you have any. Thank you.
Thank you so much. Thank you to our esteemed speakers for giving us such a detailed and 360 perspective on where we are in terms of the state of civic space and judicial independence in Southern Africa. I'm going to pose the first question to all three panelists because I think it's relevant based on what was discussed from a judge's perspective when we spoke about the judicialization of politics and the courts being used as a tool to achieve political objectives, and how we also spoke about how the courts are being suffocated financially, and that also causes an imbalance in terms of dynamics between the bench and lawyers. And lastly, how the system generally has been compromised, from not just judges to lawyers, but even court marshals and other external parties that make the system work together. So the first question I would ask for opinions, maybe we can go in the order of which speakers had spoken, is Do you think that strict independence of the judiciary is possible? So you can give your opinion on whether this is something that is realistically tenable, and if so, any recommendations that you may have. I think we can give each speaker about 5 to 7 minutes to quickly give their opinion. So I'll hand over to Judge Charles, and then we can move to Dr. Makonese, and then lastly, Dr. Mulindwa. Thank you.
Thank you. Yes, if I understood your question correctly, the question is whether I believe that strict judicial independence is possible. The answer is simply no, and that is not what is meant by judicial independence. Judicial independence speaks to the sort of the regulated relationship both between the three arms in government vis-a-vis each other, as well as the institutional independence of the operators of the institution, the judges. Now, you cannot run away from the fact that the executive command the purse, the executive command the sword. So judgments and other judicial orders will need to be enforced by the executive, and therefore that reliance and interdependence must be accepted as a necessary relationship between equals. However, we agree that the judiciary, as being the weakest arm of the three, cannot, for any reason, begin to think that when they've been, for instance, granted financial autonomy through their standalone commissions like the Judicial Service Commission, therefore they cannot, for any reason, want to have a relationship with the control of the purse. Accountability comes in. As an institution, the judiciary expends money. Somebody must account for that money from to the person who controls where that money came from. And therefore, that relationship is a given. It has to exist. But what is meant is that the giver or the controller of the purse should not, for any reasons, usually political ones, stifle or deprive the judiciary so as to achieve ulterior motives or to ensure a certain outcome or a certain to ensure that a certain environment prevails in the judiciary. So that is strictly what the concept of interdependence of the institutions entail. As for personal independence, constitutions have clauses and provisions which guarantee the independence of decision makers like judges. So insofar as that decision maker must exercise their own volition with regards to the cases that come before them, that is where that sort of strict independence ought to be applied or to be directed at, for the reasons that undue influence and will taint both the impartiality of the judge as well as of the institution itself. And therefore, when we talk about judicial independence, we are not talking about absolute independence. It doesn't exist. However, independence can be enhanced if the relationship between the institutions is regulated in a transparent and accountable manner. And to me, once that is achieved, progressively, we should be able to get where we want to be, where the respect between arms of government is mutual, and the understanding between institutions and individuals operating those institutions is mutual. Thank you.
Thank you so much for that, Judge. I'll hand over to Dr. Makonese.
Thank you, my Monday. I don't think I have much to add to what Judge Hungwe has already said. I think my view is that the way to promote, protect judicial independence is by adhering to the provisions that we have in our constitutions, in our laws, there are regulations that are supposed to be used in order to determine or guide the relationship between the judiciary and other arms of government. And therefore, as long as we are able to follow those rules, those regulations, the constitution and the laws as they are, I think to a great extent we'll be able to maintain the essence of what we are looking for when we are looking at judicial independence. The challenge comes when we have the laws and the constitutions in place, but they are not being implemented, or they are being circumvented in order for one arm of government to have undue influence or improper control over the judiciary. And I think that is where the challenge is. And as Judge Hungwe has already indicated, the independence does not necessarily mean that there should not be any cross-functional relationships between the different arms of government, but that relationship or those relationships should be properly regulated, and that regulation should not be compromised for the benefit of one arm of government over another. I think that's what I can say. Thank you.
Thank you for that. I'll hand over to Dr. Paul.
Yeah, thanks very much. I agree with my colleagues, as mentioned. Yes, judicial independence, as a principle, it allows judges to be free from any undue influence or pressure from the other branches. The fact that they get money, they get funding, the salaries from the government, that should not be a point to gag them not to exercise, to dispense their responsibilities. So this helps them to impartially interpret and apply the laws, the legislations without fear or reprisals. So as the judge mentioned, strict interdependence, that one I agree. So that the arms of governments, work together, collaborate, interact. But when we say strict independence, so I don't see it viable, and I don't think that's what the principle actually aspires or espouses. But all the arms of government to work together in a distinct way as they dispense their roles. Thank you very much.
Thank you for that, Dr. Mlindo. I think indeed complete independence is not possible, but if we are to comply with legislation, existing legislation and regulations, we can be able to achieve institutional cohesion. I'll move to the next question, which has been posed by Golani Zita. I'll pose this question both to Judge Hungwe and Dr. Mulindwa. The question says, in the difficult context where governments block the work of independent organizations like NGOs, how have you worked to build the capacity of the judiciary? So perhaps Judge can give us a perspective from the bench as to whether there's an internal acknowledgement of the role of civil society in working with NGOs, in working with the judiciary rather. And then from there, we can move over to Dr. Mulinda, who had also kind of already covered this in his presentation, but maybe to give us a bit more perspective on this question. Yes. So I'll just repeat the question again, just for clarity.
Yes, please.
In difficult contexts where the In difficult contexts where the governments block the work of independent organizations like NGOs, how have you worked to build the capacity of the judiciary?
Thank you. Yeah. Judicial capacitation is an ongoing process, and we all know that government funding is never enough for any institution, whether it's government or a quasi-government organization. As long as the funding comes from a public purse, it will usually be not just enough, but maybe it will see you through from one year to another. However, having said that, however, that does not detract from the fact that where judicial institutions need external assistance outside of government, generally the procedure that is in place is to seek the intermediation of third parties. For instance, the High Court of Zimbabwe or the Supreme Court of Zimbabwe cannot just approach an embassy, the Swedish embassy, and say, please, may you fund our furniture requirements. That is not done. However, what is done is where those would be donors or funders or partners wish to assist, let's say the example that I gave of the Supreme Court of Zimbabwe, with, let's say, a book fund or funding their library requirements, it is up to the administration of the Judicial Service Commission to approach the ministry to get in touch with the Swedish embassy that in the example that I gave, and find out the terms, the conditions, the amounts available, and so on and so forth. The reason for this intermediation is obvious. An institution like the judiciary cannot go with a begging bowl to private institutions, even quasi-private institutions like non-governmental organizations, because we know behind all non-governmental organizations, they are government donors. They are using public funds from Europe, America, or Asia to fund their activities in assisting the people of Zimbabwe, in my example. And therefore, that public intermediation is to enhance transparency in terms of how judicial activities are funded. And therefore, that intermediation is a necessary tool in the working relationship between institutions like the judicial institution and public donors. Thank you.
Thank you. Over to you, Dr. Mulindwa.
Yeah, thank you very much. Yes, just on specificity on how we've worked with the judiciary. First of all, as I mentioned in my presentation, the capacity building. Of course, capacity building takes different vast, types and modes. But what we've done in our case is training on cross-cutting issues. We've conducted one, I think, in SADC, but mainly we've been in ECOWAS and Central African Republic, where we bring together lower judges of the law, magistrates and the judges to train them to, how do you call them? Refreshing courses on cross-cutting issues like climate change and human rights, climate change and civic space, to ensure that these are integrated within their judicial policies and court rules in terms of their operations. We've also done some consultations and dialogue sessions. We did this in Malawi, we've done this in Angola. So to support the work of the judiciary to ensure that they interact with the communities, the communities also, particularly the disabled, we did this around the disabled people and women, gender and women programs to integrate their work around the lower courts in these countries. And we found out that that working with the lower courts, where most of the everyday, GBV cases and things like that start, was helping the communities, but also helping the judiciary. And in some countries, we've partnered with the judiciary to bring out like pocket policy briefs, interpret specific law and then put it in a very friendly document so that it can be distributed to the community, or sensitize the community about the operations and working of the courts. In some countries, particularly out of SADC, of course, in Uganda, there is justice, law and order sector, which is within the government, but works mainly with the judiciary. So we have tried to work with them to ensure that every year, at least, there is a retreat, either for lower judges and also for the court officers, to ensure that everything is harnessed, policies are shared, practices and experiences are shared, and then if there are any challenges, then it becomes like a dialogue. And also in some countries, we have worked with different law societies based on the arrangements and structures they have, to ensure that we work with on thematic areas, specific thematic areas of our concern or our interest, to ensure that they understand, for instance, what is at the regional level in terms of African Union instruments and UN level. As I said earlier, once and while every time there are new instruments coming, either it is a commentary on an existing covenant or convention, or it is a protocol, like in Central Africa, we've done something around the Maputo Protocol, women and related issues. So, and to interpret this into the court practices and policies helps to support the work of the judiciary. These are some of the few engagements that or initiatives that civil society can provide to support the work of the judiciary. Thank you very much.
Thank you, Dr. Mulindwa, for that. Indeed, I think there's more need for multi-stakeholder engagements to develop these conversations and continue the interaction between civil society, the judiciary, and the general public. I'm going to pose the next question to Dr. Makonese, and this is from an anonymous attendee, which discusses or wants your perspective rather on what checks and balances should be implemented to ensure judicial independence. So when we were discussing the concept of a strictly independent judiciary, we had mentioned that that's not possible, that's not tenable. And what is ideal is for us to ensure compliance with legislation and regulations that exist so that we can achieve that cohesiveness. So now that we are clearly aware that this legislation is not being followed and not being complied with, what checks and balances do you think should be implemented to ensure that judicial independence can be attained in Africa?
Yeah, thank you once again. And I think this revolves back, I think, to the initial discussion that we had, to say we are not suffering from a lack of knowledge of what needs to be done. We do have the laws, we do have the constitutions in place, which clearly explain and elaborate on how we can or we should achieve judicial independence in our different countries. What is lacking is implementation, the will, and the effort, basically, to make sure that that is achieved. And the only checks and balances that we can have, I think, will go back to what we have is already provided in our constitutions, is already provided in our laws, and making sure that what we have is actually implemented on the ground, and that failure to implement as much as possible actually has got consequences for those who are supposed to be ensuring that there is implementation, but are failing to ensure that implementation. So I don't think that beyond really ensuring that we do follow what we have, there is anything much that we can do. The only challenge that we are facing in terms of ensuring that those checks and balances are in place is the failure to adhere to those checks and balances, because we do have them. So I would say that's just where the challenge is in all our countries in the region.
Thank you. So for our last question, I'll actually feed off your response to throw our final question, I think, to the panel, to all three panelists. And this is a question from Rita Felgate, with more specifically to do with the rule of law. So basically, the question is the rule of law. I'll summarize the question. The rule of law offers a comprehensive governance model that could ideally guard judicial independence. However, in practice, the implementation and application of compliance is not really well developed. So are there any moves that you know of in that direction that are being implemented in the spaces you work, or are there any other recommendations you have? So we've spoken about checks and balances generally, but in terms of the concept of the rule of law specifically, do you think that there's any progress in that direction to ensure accountability? So I think we'll follow the same format where we'll have Judge come in first, then we'll have Dr. Makonese, and lastly, Dr. Mlindwa. Over to you.
Thank you. Everyone knows what the principle of rule of law entails. And we all know the consequences of a failure of the upholding of the principle in practice. It leads to lawlessness. It leads to so many problems, not just within government itself, but also amongst citizens. Judicial intermediation is actually meant to reduce the ever-existing tension between the different classes of societies and their relationships. Business relationship with government, government relationship with the citizens, all those are regulated by the set of laws that we agree to, from the Constitution down to the municipal bylaw. The moment the trust vanishes or diminishes that everyone will comply with the requirements of the law, and that, for instance, I'll give a very simple example of if in your country you drive on the left lane, everyone must do the same so that there is no chaos on the roads. But the moment somebody drives on the right lane, we all know the chaos that most big cities in Africa experience at rush hour. That is the consequence of a breakdown of the law and order, the breakdown of the failure to maintain the principle and uphold that principle. Now, to improve the implementation of the rule of law is a question of trust between the ruler and the ruled. It is up to the ruler who has got the power to make laws, the power to enforce the laws, to instill the confidence in the populace, in the ruled, so that they respect the law. But if the ruler makes bad law, it attracts a negative response. It is disobeyed. And those are the obvious consequences of the failure to adhere to the principle of the rule of law in a nutshell. But the corollary of this is that societies continue to develop to want better in every sphere of human endeavor. And therefore, there are always constant dynamics at play, either when you're talking in the political sphere, in trying to amend the law or amend the Constitution to provide for more liberty and to expand the civic space, or if we are talking about electoral law, to amend and allow better and more sector citizen participation, which will result in a better outcome in terms of the electoral process. So these are small steps that are taken at the macro level, which are hoped to result in an improved environment, in a better environment for the betterment of society. That will be my response in short. Thank you.
Thank you, Judge. Over to Dr. Makonese.
Unmute.
You're on mute.
Sorry. So I was saying, I think we are all agreed that basically we all aspire to a governance system that is based on the rule of law, where everyone adheres or is governed by the same laws and no one is above the law. And challenges arise, for example, even if we are looking at the issue of judicial independence, where some people within the governance system or even individuals think that they should be governed by a different law, or that the laws that are in place should not apply to them. They are a law unto themselves, basically. And this results in them not following the rules or the laws that we have in place. And I think that is the challenge when it comes to the discussion that we have been having today, to say we do have the laws in place, we do have the rules in place. Especially if we are looking at the governance system, we believe that they can circumvent the laws, they can bypass the laws and do things differently. When in fact, just adhering to what we have, adhering to the laws and rules that we have, would by and large resolve some of the many challenges that we are currently facing when it comes to judicial independence in Southern Africa. Thank you.
Thank you, Dr. Makonese. Dr. Paul, Dr. Mulindo.
Yeah, no, thanks very much. And I agree with the two colleagues. I think speaking at last time in, I don't want to repeat what they have said, but the lack of good governance, lack of all these things, of course, the first thing we need to understand or to know is justice will not be, granted. The role of the judiciary is to, bring out the justice, fairness to the society, to the community. So as long as we have this inadequate, so to say, rule of law, all hurdles towards the rule of law and constitutionalism, then the work, of course, will be hampered. What can we do to ensure that the lack of, good governance is done, is upheld? Then we need to.
Hello, I think Dr. Mulindo seems to have dropped off the call.
Hello, sorry.
Hello?
Yeah, no, sorry. Got a distraction. Yeah, so what I was saying that we need to ensure that the rule of law, as Makanata says, laws are there. We have registration, plenty of them, but implementation. Is there a will to implement the registrations? But also I go back to the point of awareness. Sometimes the societies, the communities don't know some of these rules, don't know some of these laws. People will tell you, no, that is the government. That's how the government is working. So whether it is their right, whether it is their fundamental freedom, for them, they know it has been adorned like that by God. It is constitutional. It is the powers of the government. So empowering the communities, empowering the societies, also to know how they can defend their freedoms indirectly, or rather directly, will enhance the work of the judiciary in as much as, because they don't work for themselves, they work actually, the judiciary works for the population. So empowered populace, enhanced and skilled populace will enable and facilitate the work of the judiciary. Thank you very much.
Thank you so much. I think we're going to close our plenary session here. Allow me to extend my gratitude to our esteemed speakers for your insights. I will now hand over to our moderator, Elizabeth, to continue the program. Thank you.
Yeah, thank you very much, Mirande. I thank our panelists for the beautiful, insightful submissions. Then from the discussions, we can flag the following points: that threats against judicial independence and civil space include underfunding of judiciary, lawyers not properly remunerated, appointment and removal of judges not transparent and independent, then freedom of assembly and speech not guaranteed or not enforced, guaranteed under constitution not enforced. Then we'll look at the measures to mitigate the threats. According to Dr. Paul Miluna, he says threats are everywhere, from the executive, the judiciaries, and even from the civil societies. So what can we do? He said the first that is to strengthen the protection of legal framework. Then there should be respect for human rights. There should be public opinion campaign between the civil society and judiciary. Thank you very much, panelists, participants. I would like to mention that the webinar is being recorded and will be released in due time. The webinar is being recorded and will be released. The reports will be released. The issues that have been raised with the commitment from SADC, CIVICUS, and Southern Defenders and AJJF. Now, I thank the distinguished panelists for coming out to lead in this discussion from your insights. I also thank the organizations that partnered with us, SADC, Southern Defenders, and Civicus. We hope to see you in the next webinar. Thank you very much and good evening.
Thank you.
Thank you, Elizabeth. Bye for now.
Yeah.
Leave webinar.